Good morning. It's Friday, January 9th, 2009, and we're at the offices of Weil Gotshal in the GM building in New York City. My name is Bob Zinman, and together with my colleague, Professor Richard Lieb, we teach the Bankruptcy Innovators course in the LLM and Bankruptcy program at St. John's University School of Law. With us today is Professor G. Ray Warner, who is the faculty director of the LLM and Bankruptcy program, and a group of outstanding students who have been researching the career and the cases handled by our interviewee, the Oracle of Bankruptcy, Harvey Miller. Harvey, we're really very appreciative of your making the time to let us visit with you today. Dick will now introduce the inquisitors.
Good morning. I would like to introduce our students who have worked so diligently to prepare interesting questions to pose to Mr. Miller. I'm sure he will have very interesting responses. First is Diana Ching. Diana. To her right is Massimo Giuliano. To his right is Billy Hillbold. To his right is Sean Hader. And finally, to his right is Emma O. The sixth student in our course, Thomas Bailey, was unable to be here today and regrets that he was unable to participate in this session.
Good morning. My name is Harvey Miller. I am a poor, humble lawyer who has practiced in the field of bankruptcy and reorganization for what will be pretty soon 50 years. I started practicing in a small firm in New York in 1959, and worked at that firm for 2 years when I met as an adversary a gentleman by the name of Charles Seligson, who was a professor at NYU Law School, and I think in those days probably was referred to as the Dean of the Bankruptcy Law. And I was an adversary of his in a Chapter 11 case. In those days it was Roman Chapter 11, XI. And the firm I was with represented a creditors committee, and Professor Seligson was representing a debtor. And under the old Bankruptcy Act, there was a provision that if you wanted to operate the business, the so-called debtor in possession, if required, the debtor would have to put up indemnity to protect the creditors against the erosion of values during the Chapter 11. And in the Southern District of New York, in the bankruptcy court in the Southern District, you had to have a hearing within 10 days. And I was assigned to ask for indemnity. And I was only out of law school, I don't know, 6 months. And nobody told me that nobody ever gets indemnity. So I went forward and prepared and did a lot of work, and it was clear the company was going to lose money in Chapter 11. And I got ready for what today would be an adversary hearing, and I had all these records and projections that the company would lose money. And we went down to the bankruptcy court, and the courtroom was full, and I was very nervous. And I was sitting at counsel table, which was a table about as big as this, and waiting. And Professor Seligson came in, and he was about, my guess would be about 5'6", 5'7". He looked pretty old in those days. And I introduced myself, and we shook hands, and it was a very wimpy handshake. And I thought to myself, I could take this guy. And he had a bag carrier with him, husky, strapping guy by the name of Leonard Rosen. And I looked at him, and he didn't say anything. And the hearing went forward. I should say the hearing went forward. In those days, refereeing bankruptcy. And the referee came out, and it was a referee by the name of Asa Herzog, who was a very good referee and then became a bankruptcy judge. And he came out, got on the bench and looked down, and he saw Professor Seligson. And he said, "Oh, Professor Seligson, what an honor to have you in my courtroom." And then came down off the bench, walked around the counsel table, walked right past me, and shook hands with Professor Seligson. It doesn't give you a lot of confidence. And the hearing went forward, and I had a witness, and I thought I won. And Professor Seligson got up, and he sort of stood back, put his hands like as if he was wearing robes or something, and made a long speech about the philosophy of bankruptcy and the need for rehabilitation, preserving jobs, and so on. He had no evidence, no witness. And he said, "I rest." And Judge Herzog leaned back in his chair, and he looked down at me and he said, "Mr. Miller, you made a very effective case. But I think the professor has expressed the philosophy of the bankruptcy law. So I'm denying your request for indemnity." Well, that led to a friendship with Professor Seligson, and he finally hired me. And that was a great experience working with him. And bankruptcy law, I found out very quickly in those days, was compared to doing an S1, for example, or working on a piece of a corporate deal. It had a beginning, a middle, and an end. And for a young associate, client contact immediately was a great thing. And what happened, that was 1961. I think there was if I remember correctly, there was sort of a recession in the next few years, and the volume of work really began to pick up. There was a period of time during the 1960s, I think Professor Lee would know, we had this going public thing.
Yes.
We did not call them IPOs in those days. It was going public. And as I recall, an investment banker, in those days it was broker-dealers, saying to a company, "If you could show me you have $1 million in volume, I could take you public." Doesn't make any difference whether it's profitable or not, if you have $1 million in volume. And Wall Street was very anxious to take companies public. And where in New York would you find companies with $1 million worth of volume that were private? And we used to have a big garment center. And if a garment company, whether it made blouses, skirts, whatever, had a good season and had what they called a hot number, they probably could do $1 million. And those companies started going public. The problem is, if they didn't have that hot number the next year, they were finished. So it was like an inventory coming out of the garment center of companies that either had very good seasons and then bad seasons. And a lot of the reorganization cases came out of that environment. So over the course of many years, too many to count now, we went from garment center reorganizations or rehabilitations to major companies in the world to today where we are. I mean, $1 million today is a tip for companies. And during that period, it was very interesting and intriguing to try and expand what you could do in bankruptcy. Because when I first started, going to the federal bankruptcy court was not the thing. We did, and Professor Lee may have done some common law compositions, where what you did is you called your creditors together, and there was a place on 23rd, 71 West 23rd Street, I think it was, where they had meeting rooms, and you would go in and explain to your creditors what your problems were or are, and you would basically say, you know, I've done business with you for 10 years, I need a break now. And you would try to arrange a discounting the debt, or extension of the debt, and then somebody would come in and make an investment, but you never want to go to the federal bankruptcy court. And if worse came to worse, what you did was an assignment for the benefit of creditors under state law. And there seemed to be a real reservation about going to the federal bankruptcy law. Maybe the bankruptcy or the referees at that time were a little bit more technical. Not referee Herzog, but Robert Stevenson, and there was another judge there who did everything by himself. And as a result, if you went into his office, he had every file piled up, and papers were turning yellow around the edges. It was a different system, but what intrigued me was the ability to take that Bankruptcy Act and try to expand it, which was helped, I must say, by Judge Herzog, who was also a forward-thinking judge, and working for Professor Seligson was a big help. And then in the course of my career, I ran into Professor Lee, and when I say ran into, I mean it literally. I still have the bruises, and we had some fun, I think, in those days. So I was fortunate. I think life is, you have to be in the right place at the right time. And as you have an economy that's constantly expanding, you're going to have credit problems. And I always thought that you have to have an escape valve for people that have credit problems. And the bankruptcy law provided that kind of an escape valve. And it was a great period during the late 70s, the 80s, into the 90s, because you had this robust economy that was expanding. And I was just reading recently an article about businesses are, I guess it was Hegel said, everything has within it the seeds of its own destruction. Businesses don't last that long. This report I was reading that said every registered business in the United Kingdom has a lifespan very often, I think it was 15% of less than 3 years. So even if the United States, if you look back, I forget how many years back, the top 100 companies, I think it was 1940, there are only about 35 of them left. So you have to have some mechanics, some means of dealing with that. And that's what always intrigued me.
How did you become a bankruptcy lawyer? What was your reason behind it? Did you want to become a bankruptcy lawyer before you graduated, or was it a decision that you made after you entered into practice?
When I went to law school, there weren't that many elective courses. Almost everything through the first 2 years was really required. And then in the third year, you had some options. And one of them, I think the name of the course was Creditor's Rights. And the professor at Columbia was a professor by the name of John Hanna. And he was in competition with a professor at Yale who wrote the book on secured transactions. The name will come to me. But he was like in his last year of teaching. And the first 2 sessions were very boring. So I dropped the course. So I never had the course in Creditor's Rights. And I really never thought about the concept of bankruptcy or collecting a judgment even. So my initial plan was to leave New York. And at that point in time, there was some attraction to working for the government. And I was really thinking about the SEC. The problem was that Eisenhower was the president. And he did not like the SEC, and he kept cutting its budget. And when I graduated from law school in June of '59, I guess, the federal government was operating without a budget. They hadn't passed the budget, and there was the emergency financing, which was done on a monthly or a 60-day basis or something. But I went down to Washington to interview with the SEC and so on, and they were very interested, but they said they had no budget, they had no allocation. So if I could wait until the budget was passed, and the whole summer went by and no budget was passed, and I had gone to the FAA, the Department of Labor, and someplace else, and I had basically 2 job offers if they ever passed the budget. And I was married, and my wife was working, and then she quit her job. And we spent the month of July on the beach. And then we certainly looked at our bank accounts, and there was practically nothing there. And the question was, in those days, nobody came to campus to interview. And basically, I think Sullivan and Cromwell was 75 lawyers at that time, 25 partners and 50 associates, or something like that. There weren't that many jobs around. So I took a chance. This is a very novel thing. I put an ad in the Law Journal. And the first day I got 15 responses. So I just walked around to these, some firms were downtown, some firms were in Midtown. And I was basically finished during the day, and I was at 42nd Street and Broadway, and I had a postcard from a law firm. Please call. And Dick may remember, it was from a man by the name of Frederick E.M. Ballin. And I was intrigued by what did E.M. mean. And his office was at 41st and Broadway in the Sterling Chemical Building. So I called, and he said, come right up. So I thought he was a single practitioner. But I was there anyway, so I went up, and I got off the elevator, and he had the whole floor. And I said, that's strange. And it was a beautiful office. It was all oak paneled. There's a story behind it, walnut paneled or something. And I was ushered into his room. His office was about twice the size of this room. I don't know if you remember it. And it had stained glass windows and a fireplace. And I said, something wrong with this. Why did I get a postcard, and why is this an individual practitioner? It turned out he was a Columbia graduate. And he had some sort of, was fond of Columbia. So we talked for about an hour, and he was a charming gentleman. And he said, well, there might be space for you. And then he introduced me to another partner, and I left, and I took the subway home. By the time I got home, as I walked into our apartment, the phone rang, and it was Mr. Ballin, and he said, this was on Thursday evening, and he said, can you come in on Monday? And I said, well, wait a minute, we never discussed anything about compensation. He said, we'll talk about it on Monday. So I did go in on Monday, and it didn't pay that well. I did not pay that well. I think the going rate then was like $4,200, and he was at $3,500. But I took it anyway because he was really a very charming man. And it happened that that office was handling what was then the largest Chapter 11 case in New York, a major retail chain by the name of Y Shops, which was, as I recall, it was like 1,200 stores, but they were small stores, hosiery stores and stuff. And they were just winding up that Chapter 11 case. And the associate who was working on it had left. So I think they had that in mind for me, but they didn't say anything about it. And I started working there, and later that week, I was walking down the hallway, and another partner came out of his office, and he said, hey, you, as I was walking down the hallway. And one thing I learned in the Army, never respond to hey, you. So I just kept walking. Unfortunately, the hallway ended. So I had to turn around. And he said, I want you to go down to the bankruptcy court. I had no idea what the bankruptcy court was. And you have to go in and get an adjournment of this case. And I said, I'm not admitted to the federal court. He said, don't worry about it. So he said, just go down there and say everybody's agreed to an adjournment. And it was before a bankruptcy referee by the name of Robert P. Stevenson. With that time, I didn't realize that I had written 4 other volumes of Collier on Bankruptcy with Professor Seligson. So I went down, I found the bankruptcy court, and I went into this room, and it was packed. And I said, I'm not going to get up in front of all these people. I don't know what I'm talking about. So I sat in the back, and I thought I'd listen and see what would happen. And the referee, Judge Stevenson, came in, and he was a curmudgeon. They didn't wear, bankruptcy judges did not wear robes in those days. And he came in, he was wearing sandals. And in those days they had nylon puckered shirts. And just in a shirt, and he was white hair, and he got on the bench, and he started calling the calendar. Bankruptcy judges in those days did not have law clerks. There was very little support service. And he started calling his own cases, and he called this case in which a bank was seeking permission to foreclose on collateral or something like that. and there were 3 lawyers there from a Wall Street law firm. Now bear in mind, this was the summer, and the courtroom was about 98 degrees. And these 3 attorneys were all wearing 3-piece suits. And the perspiration was just pouring off them. And this rather stuffy attorney got up to make his presentation, and Stevenson looked down and said, "Are you admitted to this court?" And that caught my attention right away. And he said, "Of course I'm admitted to the court." And Referee Stevens looked down and said, "Are you sure of that?" And you could see the expression on the man's face changed. And he said, "What do you mean, Your Honor?" He said, "Are you admitted to the federal court?" And in those days, I think you had to wait 2 years to get admitted to the federal court or something like that. And many people were admitted to state court and never got admitted. And he pressed him, and he was not admitted to the federal court. And I was sitting back there in my own pool of sweat. And he really admonished him. He marked off the motion and sent him out, "Don't ever come back here unless you have a certification that you're admitted." So the calendar went on, and I'm sitting there and said, "How am I going to handle this?" So when I got up to the counsel table, when he called the case, I said, I'd like to advise the court that I am not admitted to this court. I'm just here to get an adjournment that everybody's agreed to. And he thanked me for saying that. And then he gave me instructions to go back to the office and admonish the partner who sent me down. And I said to myself, boy, if I can get that kind of authority, this is a good court to practice in. So in any event, what really happened is I got enmeshed in this Y-Shops case. And it was before Judge Herzog. And he was a very sympathetic judge. And just by happen chance, I got involved in another case and it was before him, and we sort of established a relationship. In those days, it was not a centralized bankruptcy court. Every bankruptcy judge had his own office and his own staff and ran his own calendar. There was nothing centralized. So if you appeared long enough, as many times, you got to know the whole office staff, and it was like a family. And what I liked about it, as I said before, every case had a beginning, a middle, and an end. And you got to know the people. And when a case was successful, there's nothing like it. People were so grateful to you. So I hadn't intended to be a bankruptcy lawyer, but in those days, when you got a job, you did whatever the firm told you to do, including changing the light bulbs. But the subject matter was so interesting.
You touched upon the level of morality of bankruptcy field back in the early days. How is today different?
When I first started practicing in this field in 1960, really, the bankruptcy bar, particularly Manhattan, where I really practiced, was a small bar. And because of the nature of the business that it engaged in, it was largely made up of what were Jewish law firms. And a lot of the business, as I said, came out of the Garment Center. But in 1960 and 61, 62, as I said, there was a reservation about going to the federal bankruptcy law. And actually, the practice was divided up. There were certain lawyers who worked in the restaurant supply field. There were certain lawyers who worked in the Garment Center cases. There were certain lawyers who in the fur industry. And even in those days, there used to be a millinery. That's not surprising. You ever wear a hat? And they sort of had their territories. In terms of morality, I think they were small firms, but they were very well respected. I always remember an attorney by the name of Sidney Basil Levy. He and his brother practiced Lebanon Weintraub, Hahn Hessen. I always thought they were very highly ethical practitioners. There's always been a fringe area, but it really hasn't been that pervasive in the field. We didn't have any Madoffs in those days. Certainly not at that size. If you look at what the quants have done to the world, they do provide an inventory. I was an investment banker, lowercase, for 5 years. And one of the things that sort of I did not like about investment banking is what you're always doing is you're trying to sell somebody to do something they don't want to do. So you go to a business that is fairly profitable, the management's pretty happy, the stockholders are pretty happy, and you tell them you're too focused on one stream of business. You really have to diversify so that you can spread the risk, and you persuade them to buy companies. So they keep buying companies, and then when you run out of buying companies, you go back to them and you say you're too diffuse. You have to go back and concentrate on your core business. Business schools today, I think, encourage all kinds of risk-taking. Everything is put into a model. I think if you look at the subprime crisis and you look what people are able to do with using models instead of risk analysis, in taking a pile of subprime mortgages and converting them into a residential mortgage-backed security, and using a matrix to say, well, we have 10,000 mortgages in here, only 4% will default, and using a model that only went back 5 years and never included a recession, I think has a defect in it. So yes, I think business schools are great providers of inventory for restructurings. Maybe not bankruptcies, but restructurings.
So you're happier on the legal side rather than on the business side?
I personally am happier practicing law because I like practicing law.
Starting in the 1950s, the Supreme Court began to diminish the role of the SEC in bankruptcy with cases like General Stores Corp. v. Schlensky and Grayson Robinson v. SEC. And then in 1978, Congress essentially removed all of their power within bankruptcy. Now, after the era of fraud earlier this decade, it appears that the SEC seeks to play a bigger role in bankruptcy, at least in the high-profile cases. What do you think the role of the SEC should be in bankruptcy?
Well, when I was practicing during the years prior to the enactment of the Bankruptcy Code, I actually cut my teeth, really, in Chapter 10 cases. I had Chapter 11 exposure, but I spent a lot of years in Chapter 10 cases with the SEC. And the SEC played a very good role because it had a unit which was really formed under the Public Utilities Company Act, which analyzed Chapter 11 plans. The problem with the SEC was bureaucratic, and it largely operated in the context of black and white rules. And you had to be in Chapter 10 if you were a public company, and then we stopped that. And I was heavily involved in the Grayson Robinson case, which if we had more time, I'd tell you some stories about it. But a oversight agency, whether it's the SEC or something else, I think could be very useful because the way Chapter 11 under the Bankruptcy Code has evolved is it's become sort of a closed society. The complaint about the SEC is the delayed cases. And to some extent that was true. Federal agencies tend to get too bureaucratic at points in time. But there is something missing in the process today because we have these endless debates over valuation. And I've always thought that there should be some way of changing that so that we don't have to have ex-investment banker testifying on behalf of the senior creditors that the valuation is low so that the juniors don't participate, and then having another investment banker. And you can really get an investment banker to testify pretty much anything. I don't think that should be printed. In any event, if you tell me the name of the investment banker, I can tell you where it will come out. And there should be a system, I think, where there's, I don't want to call it an ombudsman, but some maybe agency appointed by the court or firm appointed by the court and say, this is the firm that is going to do the financial analysis. And everybody will use that firm. So it's something different than the SEC, but something like the SEC. I think the SEC was great because it was impartial and objective. Today we have really vested interests in these Chapter 11 cases, and I think that's a hindrance.
Do you believe U.S. Supreme Court decisions in cases like Dusnup and Marama, where the court seemed to stretch the language of the code, and there's cases like Piccadilly, where the court strictly construed the language of the code, make bankruptcy law unpredictable?
Predictability in bankruptcy cases is a difficult subject. If you are involved in reorganizing business entities, you cannot operate in a court which is, let me call it, literalist. A statute, an effective statute, has to be flexible. It has to bend with the wind, depending on the circumstances. One of the problems with the older referees in bankruptcy, and one of the referees used to say to me, "Don't come to see me unless you can show me someplace in the book where it authorizes this." In contrast, and why I enjoyed Judge Herzog, is he was, you might call him an expansionist, but he would read a section of the Bankruptcy Act and say, well, I think within this section we can do this. So the Piccadilly case, I think, is a sort of a spore. It's an issue. It's not terribly dramatic, but cutting back because you can't find the specific word in the statute. If you're talking about reorganizing a company, you have to be able to be flexible. And if you go back to railroad reorganizations, which really is the start of reorganization law in this country, the equity receiverships, there was no legal precedent for that. In fact, there wasn't even a case in the oral controversy. It was a judge up in Connecticut who said, we can't let this railroad go out of business. Now, if you adopt that, you may call it equity power. I get a little confused about equity powers. But a bankruptcy court has to be willing to take a certain level of chance in construing a statute if you want to fulfill the objectives of the statute. And I'll give you an example. A recent example, Lehman Brothers. Here you had this huge operation, $600 billion in balance sheet assets, $600 billion in balance sheet liabilities, facing a calamity. And whether it was compelled, coerced, or what, being in bankruptcy, the most unplanned Chapter 11 probably in history. Everything done in the space of 5 hours just to get into the bankruptcy court without compliance with whatever else you had required to file. And then at 2 or 3 a.m. in the morning, and then the next day, the same day as filing, trying to figure out what are we going to do with this mess now, which has 600,000 customer accounts in the broker-dealer. So finding somebody to buy those assets, and then having the seller say, I'm not going to buy those assets unless you can get bankruptcy court approval, and I can fall under the protection of Section 363 of the code and get an order saying that it's free and clear of claims. Well, that was a real problem to confront. How to do that? So signing an agreement on Tuesday morning, the 16th of September, with a requirement that you had to have an order of sale on the 19th of September. I don't think that's ever been done before, particularly in something of $70 billion of value. Well, the bankruptcy judge, if you read his opinion, which is, it's an oral opinion in the record, said, I never realized the power I had. And what were we doing? We were taking the statute and we were saying, you can do this under 363. The only issue is the question of due process. And we will give notice on websites and television and so on. And of course, there were 125 to 200 objections that came in. Tuesday, we filed the motion to approve the sale procedures and have the sale on Friday. The hearing on the sale of procedures was on Wednesday. And people came in, and probably if Professor Lieb was practicing, he would have come in and been at the head of the line saying, this is a violation of the constitutional right of due process. The courtroom was packed. There were so many people that they opened up 2 other courtrooms for it. The hearing went on till from 4 o'clock in the afternoon to something like 9 or 10 o'clock at night. And finally, the bankruptcy judge said, well, I don't see how you can complain about due notice. Look at how many people are here, and you're here. So I think we're going to go forward on Friday. So the Friday hearing went from 4 to about 1 a.m. And people kept raising the due process. But the bankruptcy judge said, look, I have a problem. If we don't do this, these assets will erode. They'll be gone. And on top of that, these customers, Lehman Brothers Inc., they'll have to wait 2 or 3 years till they can see their securities or their money. I can't allow that. Now, it was within the framework of the statute. And we'll know whether it's good because there's an appeal pending. But to do reorganizations and restructurings, you have to have some flexibility in the statute. There's no statute that can cover every single situation. And what we have seen, certainly since the 80s, is a cutback and a cutback and a cutback on the discretion of bankruptcy judges, to the point where it is almost, I wouldn't say it's impossible, it's very hard to reorganize a company. If you look at reorganization cases today, they aren't being reorganized, they're being sold. They're being sold, the assets are being sold in the first 30 days of the case. And then there's a plan of liquidation. And that's an evolution that has occurred, which I don't believe is in the best interests of reorganization or ultimately in the country. We've gone through a very difficult period.
Statistics from the U.S., from the Administrative Office of U.S. Court shows that a vast majority of cases that do file for Chapter 11 do not end up in a confirmed plan of reorganization, like you said before. Furthermore, plans that are confirmed, many of them end up in default. So do you think that the Section 1129 plan requirements, particularly the feasibility requirement, is too strict or unworkable? Would you suggest any changes so that more plans of reorganization are successful?
The successful reorganization, so that you do not return to bankruptcy, is a difficult thing. And again, I come back to my comments about business schools. Courts look to investment bankers to testify that this is a feasible plan, and the financial analysis supports it. And there's a theme through the questions here. One of the problems is a bankruptcy judge is a judicial officer who decides controversies. What happens in Chapter 11 cases, and I think it was part of the paradigm that was designed in 1978, is the theory was that sophisticated debtor and sophisticated creditors will get together in a room, and they should be able to come up with an economic solution to the distress. And the premise of that was a case under old Chapter 11 XI called United Merchants and Manufacturers, which was a huge company for in those days. It owned a factoring company, it was international, it had manufacturing entities. And the SEC in those days said, we're going to move to convert the Chapter 11 cases to Chapter 11 the Chapter 11 to Chapter 10 cases. And we went through the same thing that had occurred in Grayson Robinson, give us more time. And finally the SEC said, we'll give you 1 year. If you can come up with an acceptable plan in a year, we won't move to convert it to Chapter 10. So the creditors and the debtors got together, and they actually spent a lot of time in a conference room. They were not allowed to go out and use the facilities, and they weren't fed. And they came up with a plan. In fact, someday you talk to Professor Lee, there was actually a fist fight in one of those rooms. And they came up with a plan that appeared to be feasible. And the people who drafted the bankruptcy reform, the new Chapter 11, used that as a base. That evolved into situations today where creditors committees and debtors get together, and there may be one or more committees, and they agree on a plan. And then they go to the bankruptcy court, and then you have to deal with the confirmation standards in Section 1129. And one of those, of course, is feasibility. Well, everybody stands up in front of the bankruptcy judge. You're all the judges, and I stand up and say, everybody's agreed this plan is feasible. So what do you want the bankruptcy judge to do? The bankruptcy judge is not going to get down off the bench and say, wait a minute, I'm going to test this. Professor Lopucky is very critical of bankruptcy judges on this point. But I don't think bankruptcy judges decide controversies, not when everybody comes in and locks hands and say, we all agree. So feasibility becomes the subject of this conference. Creditor interests are dependent on what are they getting immediately. Some creditors want some cash right away. Some creditors are going to be in for a short period of time. And then we've had a different constituency, because claims trading is such a big factor in what we do. So claims trade all the time. And people come in and they buy claims at a discount, and they're very satisfied. If they bought at 10% of face and they're getting value at 25%, they're not going to stay with the company that long. So we have big problems in feasibility. Now, if there was some independent ombudsman or somebody who reviewed the plans or actually conducted a pre-hearing for the bankruptcy judge, if you go back to Chapter 10, the United States District Judge who presided over Chapter 10, unless it was referred out to a bankruptcy judge, would not even consider a plan until the SEC said this plan is worthy of consideration. So now we have very interested parties determining feasibility with no independent oversight. And that's maybe an area where we need some help.
Mr. Miller, my question deals with the problem of creditor apathy in bankruptcy. Creditors are envisioned to play a vital role in that they act as a watchdog or provide a check against the debtor in possession's actions. You wrote an article in 1995 stating that U.S. trustees and bankruptcy judges are capable of picking up the slack in cases where creditors' committees haven't been formed or where they're not functioning well. Does the U.S. trustee or bankruptcy judge have enough resources to adequately address that problem?
The issue of creditor apathy is one that, in my own mind, I've distinguished between the individual creditor who has a claim, but not a very significant claim, and the actual administration of the case. There are very few cases in which a creditors committee is not appointed. And the way the U.S. trustees' offices work now, creditors committees are appointed very quickly. If you look at Lehman, because of what was happening in Lehman, the U.S. trustee appointed a committee on the second day of the Chapter 11 case. If you look at Refco, which was it was a big fraud case in the commodities trading area, the U.S. trustee appointed a creditors committee in the first week. So there are creditors committees which are organized very quickly. In addition to which, bankruptcy is now a very respected element of the practice of law. Every law firm deals in bankruptcy. When I came to Weil Gotshal in 1970, people said, Weil Gotshal must be crazy. Why would they want a bankruptcy department? And there were many firms, and Professor Lieb can tell you about some of the firms, wouldn't touch a bankruptcy case. Or they had a professional associate who did the bankruptcy work. As soon as people began to realize, and this may be, I shouldn't say this to students, that there was gold in them, their heels, you can make fees. And that's actually not correct, because if you go pre-World War II, and you go into the period of the 30s, all of the Wall Street firms were in those reorganization cases, those big the railroads and all of those cases. What changed was World War II, there were no bankruptcies. But when we got into the 70s, there were a lot of bankruptcies. And what happens today is there's more, what would be the opposite of creditor apathy, creditor activity, I guess. In 2 days in Lehman, we had 4 ad hoc committees. And today, ad hoc committees are a big thing. We have big problems with Rule 2019, where you have to disclose your relationships. But I don't find in major cases, and unfortunately, my perspective may be limited to that, there is anything like creditor apathy. And beyond that, if you go from 1979, when the code became effective, to the amendments that have been done over the years, and particularly the amendment of Section 105, which gives the bankruptcy judge the right to call conferences. When we started in 1979, the bankruptcy judge was not supposed to be involved in administration. That was a reaction to the so-called bankruptcy ring that operated prior to that time. And it was only the bankruptcy judge was supposed to be put in deep freeze. When you had a controversy, you defrosted him and brought him back in, or her. I always found that having the bankruptcy judge know what is going on in the case is helpful. We used to have first meetings of creditors in the bankruptcy court. It was always an amazing thing. We never got to a second meeting. It was always the first meeting for 3 years or so. And used to go into court and report to the bankruptcy judge the state of the estate. In a retail case, that the sales were X and the gross margin was X. That all came out. It has now sort of crept back into the bankruptcy law, bankruptcy administration, I should say. And bankruptcy judges can pick up the slack. And the Office of the United States Trustee in Delaware, in New York, is very active and sometimes gets too involved in the case. So I don't think creditor apathy is a problem.
In Owens Corning, the court described substantive consolidation as rough justice and something that should be used sparingly. And then in the DC Circuit case, Auto Train, they used a different test for balancing the equities and creditor benefits outweighing the harms. What do you believe the standard for substantive?
Substantive consolidation has always been a problem in major Chapter 11 cases because so many companies operate with a holding company and a whole array of subsidiaries. The functional approach, let me call it, is how did the creditors do business with this company? Did the creditors consider it one company? And were the relationships basically on one ball of wax, so to speak? The decision in the Third Circuit is a well-written decision. I think it expresses the law, but I never thought the law was that complicated. Way back, there's a judge in the Second Circuit, Henry Friendly, who was an amazing judge, in a case called Florimir, laid it all out. Florimir was a company that had filed. Before it had filed, it had acquired another company, a public company, which had public bonds. And Judge Friendly, I think, is the one who coined the phrase that substantive consolidation should be used sparingly. And from my perspective, it's a factual test. I think the Auto Train balancing of the equities is a little bit too vague and opaque. Balancing the equities gives you too much room. On the other hand, there are some aspects of Judge Ambrose's decision which I don't like. Again, I think there has to be a level of flexibility in dealing with the situation. If Lehman was really in a reorganization rather than a wind down, you're talking about a company with 4,000 subsidiaries. And the fact of the matter is most people did business with Lehman as Lehman. So it's a evidentiary issue in my mind. And I don't like the concept of balancing equities. It's too loosey-goosey.
You've written about whether going concern value is a concept of the past. Do you feel that it really is a concept of the past?
When I wrote that, I think I was talking about what had occurred over the years prior to 2008. The paradigm of Chapter 11 was a distressed company that needed relief, and it needed more than a financial deleveraging. It needed an operational overhaul. And sometimes that will take a lot of time. We moved into an economy which various people have described as robust. And what happened during that period of time is the marketplace for assets expanded and became much more realistic. When I was a young attorney practicing and we had a case that was not doing well and turned into a liquidation, and you had a bankruptcy sale representing a trustee, nobody came to the sale. So when you took a company into reorganization, everybody said, we don't want to sell the assets, because if we sell the assets, we'll get liquidation value, and there'll be no distribution to creditors. And that helped to keep the case going, because when you were negotiating with the creditors committee, you would say to the committee, you don't want us to liquidate, because if we liquidate, you won't get a distribution. What happened in this period, this 5-year period approximately before 2008, was suddenly assets in bankruptcy cases became valuable. In my career, I never saw Warren Buffett come to the bankruptcy court. Wilbur Ross made a career out of buying assets out of bankruptcy cases. So what happened is the academics, I'm excluding you gentlemen, the academics said, we don't need Chapter 11 anymore, because there's a marketplace out there that will pay true value for the assets. And you could transfer the assets without all of the problems of Chapter 11 immediately, and then let the creditors fight over the proceeds. So the concept of preserving going concern value in Chapter 11 began to dissipate, because the argument was always, we are going to get going concern value by selling the assets. That was the context in which that, whatever I wrote, came out. I think that may change now. I think in the current economy, in the credit crunch, there aren't people around like that. But that was a real change. I mean, when Wilbur Ross came in, for example, who's a great entrepreneur, and bought LTV assets for something like $42 million. And these were steel plants that cost $6 billion to create. And turned that around, and then ended up buying Bethlehem and creating the International Steel Group, and then selling it to Mattel. Everybody said, this is something we ought to be doing.
You're viewed as the father of modern bankruptcy law, and I think that's largely because you've been the most creative interpreter of the bankruptcy code, and you've explained today a little bit about how your early relationship with referee Herzog launched you on that sort of path. What I'm curious about is what you feel is your greatest achievement in being creative in interpreting the bankruptcy code as a legal device. So not the practical things you may have done in a case that were particularly creative, but something that you see as the most significant creative interpretation of the bankruptcy code that you've been able to achieve.
It's very difficult for me to come up with an interpretation of the code that I would consider the most significant. I think we did a lot of work on 363, the ability to sell. I think and I shouldn't put it in personal, because the key to whatever I've done are the people who did it for me. So let me think. It really, I mean, it was a combination of things. And lucky breaks, the concept of the doctrine of necessity, which evolved into the critical vendor, being faced with a company that was going to fail unless it could get a particular part. It was people just sitting around saying, well, what are we going to do? And collectively coming up with the thought, there must be something called necessity. Can we persuade a bankruptcy judge to do that? Some people would call that reorganization uberalis. I think actually that theme, being able to convince a court, and not only court, the creditors, or the stakeholders, let me call it, that there was a virtue in preserving this company, that you could actually preserve jobs, you could benefit the economy. I look at that as a better thing than just technical interpretation of the code, creating an atmosphere in which you can get people to agree to that.
Mr. Miller, I'd be interested in your reaction to the fast-track provision for single-asset real estate entities, and whether that's an appropriate reaction to those circuits that had frequently dismissed real estate cases on a bad faith cause theory.
I always found the decisions, particularly in the 11th Circuit, which became somewhat famous for dismissing cases as bad faith filings because they were filed on the eve of the foreclosure, to be problematic. And if you have a bankruptcy law which is intended to protect, at least to some degree, debtors, and taking the economy we're now living in with the extent of real estate, residential real estate foreclosures, I think it provides an avenue of protection. In fact, I think I read yesterday that there is now a movement in Congress to give bankruptcy judges the right to change the terms of mortgages in Chapter 13, which I think is a very good thing to happen. When they took that discretion away, it was a terrible thing. So while I have no experience with that, the only single asset real estate case I really have been involved in was Rockefeller Center, where I argued that it was a single asset real estate case. A little interesting. Not under that code provision, but I think it's a good thing. I think it was thought out, and it should work.
Thank you.
I wonder whether it really does anything in the sense that the judges still have the authority to extend the stay. So even if it says that there's you have to make a payment, they don't have to do that if the court extends the stay. So I wonder how effective those provisions will really be.
Here's a provision where you are balancing the interests of the different parties. And in the context of the economy we're in, I would leave the discretion to the judge. You know, as a young lawyer, I always remember being engaged by a bank to go and get, well, to represent the bank in connection with a Chapter 11 debtor. And in those days, we always used to make a motion to modify the stay. Very few were ever granted. I don't know how I did it, but I got it granted. And I remember coming back and calling the client and saying, we were successful. The stay's been vacated, you can go ahead and get the collateral. And there was this long silence on the other end of the phone. And I said, are you there? And finally the banker said, yes, but what am I going to do with the collateral? No, and on this, just as an aside on this foreclosure situation, I was invited to speak at the New York State Judicial Conference where all the state court Supreme Court judges were coming in. And I was just amazed at listening to the judges that foreclosure dockets are unbelievable. And what they were complaining about is there are the service of foreclosure notices, sua service, and the use of false names, and no attempt to notify the mortgagor. And they were really irritated about it, but they said they don't have the facilities to do anything about it. It's a real problem.
Corporate debtors often sell major assets or a large portion of their assets under 363 rather than doing it pursuant to a plan of reorganization. Although parties favor these sales because they're relatively inexpensive and less time-consuming, do you think these sales avoid the protections built in 1129A?
You all ask very good questions. Every process that or procedure that we have developed, and I say we in the broad context, sometimes gets overused or overexpanded and sometimes abused. There is the possibility in 363 of circumventing protections that were there, put in there for the protection of the interests of stakeholders. I believe a 363 sale, properly conducted, with appropriate interest and creditor input, can, in the right circumstances, be a good thing. There are some companies who have assets that simply don't function well in the environment of a Chapter 11. I'm sure you've read in the newspapers recently the great issue about the automobile companies. If one or more of the automobile companies were to end up in a Chapter 11 case, could that automobile company actually sell vehicles in a Chapter 11? What are you going to do about the warranties? What are you going to do about the dealer programs? What are you going to do about servicing? What are you going to do about financing? Now, I'm not saying that a 363 sale would actually work with one of those companies. They're probably too big. 363 serves a useful purpose when you have assets that are subject to major erosion. In the current environment, I think there are problems with 363. But it's being used because the ability to reorganize the way we used to reorganize when Professor Lieb and I were young is almost non-existent. The Chapter 11 environment has changed dramatically because today, almost in every case, the assets are subject to liens. Everything is liened up. I'm always amazed how long it took the institutions to find the Uniform Commercial Code, but they found it. So what happens today is a company gets into distress. Nobody wants to go into bankruptcy. Most people say my book only goes up to Chapter 10. So you keep putting it off and you keep putting it off. And the problem is you put it off too long. So then you need debtor in possession financing. Well, all your assets are subject to liens. So what do? You go to your current lender and you say, look, you want to protect your collateral. You need to give us financing for the Chapter 11. Well, if you look at a debtor in possession financing agreement today, it is so onerous that the CEO's son is usually held as a hostage. You cannot do anything. Take a case like Circuit City. I hope you know something about Circuit City. It is a major retail chain, electronics chain, having a very difficult time of existence, particularly in this economy. It was in trouble even before this economy. So it was a borrower from Bank of America before it filed. It had a chain like that has a revolving credit agreement, may have a term loan, usually doesn't draw heavily on that until it's stocking up for Christmas. So it stocks up for Christmas, it borrows on the credit facility. So it borrowed about $800 million. As they got closer to Christmas, they recognized that they weren't going to make it. So they decided to file a Chapter 11. They go to the Bank of America for debtor in possession financing. And they get debtor in possession financing of, I think, $1.2 billion. So how did it get to $1.2 billion? Well, they rolled up the $800 million into the debtor in possession financing, which in some ways I think is a violation of the Texlan decision. But they roll it up. And then they put in restrictions. You have to have reserves under the financing. So although it's announced as $1.2 billion debtor in possession financing, $800 million is not there. There's a $200 million reserve. So they have borrowing capacity of $200 million for which they paid in fees and commissions and so on, $44 million. So they basically have no credit to operate. So what's going to happen to Circuit City? My guess is before the end of the month, they'll go into liquidation. And what it'll be a 363B sale, because who will buy it? Gordon Brothers and Hilco, the liquidators, who already are in the company advising it. So I think there's a problem about that. But my real concern today is that the ability of a company to actually reorganize in the environment of Chapter 11 is so limited that if you do a survey, I think you will find most of the companies are selling their assets very quickly after filing. If they can find a stalking horse. Some people say all you need is 105A and 363, and you can forget about the rest of the code. I don't think that was what was intended. I think bankruptcy judges have an obligation to look at the 363 process and see, is this really necessary? But that hasn't happened yet.
Earlier, you had mentioned that bankruptcy is like an escape valve for companies. Do you think that the bankruptcy code can handle some of the current issues facing the economy today? Some of the corporate debtors who are filing for bankruptcy, Lehman, there are new financial transactions. That do you think that the code is flexible enough to handle the reorganization of these giant institutions?
It's a good question. These cases are not really reorganizations. They're basically winding down these businesses. In the case of Lehman, the bankruptcy code really is not adaptable to actually operating the business of a financial institution. Indeed, when we thought about it, we said it's too bad that we're not operating in Italy, because when Parmalat had a problem, I hope you know a little bit something about Parmalat, the Italian government immediately passed a new bankruptcy law just for Parmalat. In the context of a financial institution, the bankruptcy code is not really equipped for the operation of a business like a Lehman. And the question is whether there should be a separate proceeding or process for a financial institution. We do have that to a certain extent in the Securities and Investor Protection Act, but that's just the liquidation, and that's just to protect public customers. I learned a long time ago that the original concept of bankruptcy was banks and insurance companies who are not qualified to file, but banks and insurance companies and financial institutions really don't need reorganization because you're just talking about money. Money's fungible. Lehman can run money or X can run money. That the bankruptcy law was really designed for commercial businesses, automobile manufacturers, automobile supply contracts, airlines, things like that. It doesn't really fit for a financial institution. And the code now is, I don't know how many years now, probably is due for an overhaul. It was drafted and adopted in the context of a world that Professor Lieb and I lived in which there were large amounts of unsecured debt. We don't have those situations anymore. The way companies are financed has changed a great deal. Claims trading has changed a great deal. So I think we're ready for a reappraisal, if you will, of the bankruptcy law, and how should it be changed, and should there be different conservatorship laws or something for other kinds of institutions. Hope that answers the question.
For those of us who are entering into and aspiring to succeed in the bankruptcy field, I was wondering if you have any advice.
Yes. Work hard. Be prepared. Preparation is really the most important thing. Know your subject. Have good adversaries like Professor Lee. They teach you while they batter you. And try to have some fun while you're doing it.
If there's any question that should have been asked that you can think of, or any concluding remark that you'd like to make for this interview, we'd appreciate it. It's been a very exciting and informative session that we've had, for which we do thank you.
People should work hard to improve the law. That's all.
Thanks very much.
Now, I have to say this, that many, many years ago, I wrote a law review article. It was a long time ago. And I ended up in the Fifth Circuit Court of Appeals in a case with a gentleman you may remember, Morris Macy.
Oh, yes.
Who, when he argued against me, whipped out the law review article and said, well, wait a minute, Mr. Miller just said this in this article. And I vowed that as I left the courtroom that day, I was never going to write another thing, nor would I ever be interviewed again. I relaxed from that rule. But for a long time, I did not write anything. And I thought of a story about Professor Loss from the Harvard Law School, who was a great securities analyst. And I was in the Second Circuit Court of Appeals waiting for my turn to argue. And he was arguing a case, and Henry Friendly was the presiding judge. And Judge Friendly said, 1 minute, Professor Loss. I am totally confused by your argument. I just read your law review article on this subject, and it is diametrically opposed to everything you're saying. And Loss just looked up at him and he said, yes, Your Honor, I understand that, but I want you to know I think better when I get paid for it.
I thought he would have said, but no court has ever agreed with me.
No, when he said that, I said, why didn't I think of that? I wish you a lot of success.
Thank you.
It's a great field.